next session, I give the floor about the control, the monitoring of of human rights at external borders to Catherine Woolard, who is the director of ECRE, a very well-known NGO in Brussels, an umbrella NGO, European Council on Refugee and Exile. And of course, I think it was logical to have as a chair an NGO for about a session regarding human rights. Thank you, Catherine.
Thank you so much, and welcome everybody to this panel. The panel is entitled Externalising Human Rights at the Border. This is, of course, an issue that is high in the news, again, due to a terrible and avoidable tragedy, another shipwreck in the Mediterranean 2 weeks ago. For this panel, we're going to follow the same structure as the previous panels. We'll start with a presentation from Professor Dr. Iris Goldner-Lang, who, among many other accolades, is the Jean Monnet Professor of EU Law at the University of Zagreb. Her presentation will be followed by comments, reflections from two eminent panelists. We'll start with Jonas Grimheden, who is Fundamental Rights Officer at Frontex. That is certainly a hot seat, we might say. And then Dr. Eva Zaharieva, who's the JHA Councillor at the Permanent Representation of Bulgaria here in Brussels. So with that, I'd like to give the floor to Iris, please. Go ahead.
Thank you so much. Let me just see. Oh, yeah. Okay, it's here. So thank you so much, Catherine, for this nice introduction. And of course, a big thank you to the organizers, in particular for Philippe, for putting us all together and organizing this in such a great way. So I will be kind of warming us up for what follows as regards the externalization of human rights at the EU's external borders, which is the title of this panel. And my plan is to discuss the externalization by looking at two things. First, by looking at the application of new technology at the external borders and seeing how that will contribute to further externalization of human rights at the external borders. And then at pushbacks and something that I refer to as legal pushbacks, and I'll explain what I mean by that. And then I will refer to the so-called national independent monitoring mechanisms that will have to be implemented, established based on the proposal for the screening regulation. And I will look at the Croatian experience with that regard, and also at some open issues in this context. Now, moving to my first point, what I want to look at in the context of the application of new tech in the EU border management, I want to first briefly address border surveillance and then border checks. And I want to show or argue that basically the application of new technologies at the EU's external borders towards third countries has as its primary objective the protection of national security. So it's all about security, and this is something that I call the national security creep, which I define as the expansion of national security-related use of technology in migration and asylum. And this is something that I've been exploring lately within the framework of the project that I'm part of, which is called Algorithmic Fairness for Asylum Seekers and Refugees. Of course, there are other objectives of the application of modern technologies in the border management, such as looking at the market needs, considering how to improve efficiency, transparency, and so on. But I think that these are, when it comes to border management, just secondary objectives, marginal objectives, whereas the primary objective is security. And this is why I call it the national security creep. Now, looking at the border surveillance, what we can expect in the near or midterm future is the huge developments in this area. Some of these things that I've put on this slide already exist. Some of them will be developed and much improved in the years to come. And here I'm referring to the so-called unmanned aerial systems with full autonomy, object detection, processing of imagery, and classification. Also heterogeneous robotic systems, which would be interoperable aerial, water surface, underwater, and ground vehicles. Also, the use of surveillance towers with automated object detection and surveillance of large areas, much larger areas than are currently possible to surveil based on the current surveillance towers, and then face recognition technology. Border checks, here primarily what we have are the automated border control gates, which are integrated e-gate hardware, which enable document scanning and verification, facial recognition, and other biometric verification. Now, looking at the proposal for the amendment of the Schengen Borders Code, which has been discussed a lot over the last day and a half, as we all know, there is for the first time the definition of instrumentalization in this proposal, which will enable EU member states, first, to limit the number of border crossings and their opening hours, and second, to increase border surveillance, in particular, the sources and here I emphasize, technical means to prevent an unauthorized crossing of the border. So putting this all into context, it seems to me that what we can expect, not just due to the fact that modern technology is just developing so rapidly, but also because there is, a space for that based on the current proposal, that there will be even more and more use of modern technologies at the EU's external borders, and that this is something that could, first of all, lead to more pushbacks. And also, there is this, it seems to me, presumption of, a third country national being suspicious. And here I'm referring to the so-called automatic suspicion towards third country nationals. I'm referring to Chris Jones' writing on this in State Watch. Now, as I said, the use of modern technologies at the EU's external borders might have a negative impact of, even more pushbacks, because basically you are able to detect all sorts of movements and third country nationals from much further afar and so on. As we all know, there have been a lot of writing, a lot of different comments and critiques about pushbacks happening at the EU's external borders in a number of EU member states. But on top of that, there are, of course, some quite noteworthy court developments by the European Court of Human Rights. And there is a whole line of case law starting from ND and NT, moving on to MK against Poland, MH against Croatia, an AA against North Macedonia, which basically kind of give the green light to EU, to states, to European states, to impose certain deterrent activities when confronted with the possibility of new migration influx. And what they do is kind of differentiate between what we might call good and bad migrants. And good migrants could be those who come to the official border crossing point, whereas bad migrants are those who come to the green border. And what the European Court of Human Rights has said in all these cases that I've put on the previous slide is that pushbacks at the green border do not violate the convention, even if individuals approach the border peacefully and in small numbers, and even if there is no use of force, as long as the host state genuinely and effectively enables individuals to apply for asylum at the official border crossing point, and there are no cogent reasons for individuals not to make use of official entry procedures. So these developments are something that is giving kind of a wind in the back of European states to actually apply different deterrent activities in between official border crossing points at the EU's external borders, at the green borders. Now, what is the future with regard to these illegal and legal pushbacks? First, as regards the case law of the European Court of Human Rights, we have to wait and see what will be the reaction of the Court of Justice of the European Union. Whether the Luxembourg Court will just follow the same line of reasoning of the Strasbourg Court, or whether they will take a different stance. Also, there is, of course, the question whether we have sufficient and adequate EU-level mechanisms to respond to these challenges, so basically both legal and illegal pushbacks. And then finally, whether the current proposals to establish national independent monitoring mechanisms are the right response, whether they are able to respond to these challenges effectively and appropriately. Now, here I would like to first look at the proposal for the screening regulation, which states in its Article 7.2 that each member state has to establish an independent monitoring mechanism to ensure that in relation to the screening, fundamental rights are observed and any allegations of the breach of fundamental rights are properly investigated. So here I've put in bold that the monitoring based on the screening proposal is just about the screening phase happening at the border, nothing else. It's not about border surveillance. It's not about border procedures. So the monitoring that is supposed to be performed by these national mechanisms based on the proposal of the screening regulation is very limited. It's very, very narrow. Based on the screening proposal, the national monitoring mechanisms would need to ensure compliance with EU law and international law, including the Charter, but only during screening, compliance with national rules on detention, and that allegations of non-respect for fundamental rights, again, in relation to screening, including in relation to access to the asylum procedure and non-compliance with the principle of non-refoulement, are dealt with effectively and without undue delay. And what the proposal also states is that there is a role for Fundamental Rights Agency. So FRA has to issue guidance on setting up and ensuring independence of such mechanisms, and member states may require the agency to support in developing these mechanisms, including safeguarding independence, the monitoring methodology, which is extremely important, and training schemes. And they can also invite international entities and NGOs to participate in monitoring, and they should function in parallel with the monitoring conducted by Frontex, so by the fundamental rights officer, and also other national monitoring mechanisms that exist either by the National Ombudsperson's Office or anybody else. And here I would like to briefly look at the Croatian pilot project that was established on the 8th of June 2021. And it was established, this independent monitoring mechanism in Croatia is the first of its sort. Currently, there is also something that just recently appeared in Greece, but the Croatian one was a first, and it's not because Croatia is so, far ahead in comparison to other states, but it was just really literally pushed by the Commission to do so. And Croatia, was obedient because it wanted to join Schengen. So the Croatian monitoring mechanism was established in 21 for 1 year with a possibility of extension. And also a new agreement has been signed rather recently in November last year, this one lasting for 24 months, and again with the possibility of extension. And this mechanism has a much broader scope than the mechanisms that are proposed by the screening regulation, because its aim is to monitor action of Croatian police officers in the area of border surveillance, irregular migration, and international protection. So something that is not stipulated by the proposal for the screening regulation. It's supposed to cover all border surveillance. And it's supposed to take place at the Croatian external borders towards Bosnia and Herzegovina, Montenegro, and Serbia. So, of course, it's not including the internal borders towards other European Union countries. And the location of the monitoring is not just the official border crossing points, of course, but also the green border, police station, police administration, and also the reception centers. Here I've put just for you to look at the coordination board of the Croatian independent monitoring mechanism. There are 4 NGOs involved. The Croatian Red Cross Center for the Culture of Dialogue, Croatian Academy of Legal Sciences, Croatian Academy of Medical Sciences, and I'm the only natural person involved apart from the four NGOs. And each NGO appoints 2 monitors who conduct at least 20 observations. So there are altogether 8 monitors. And the monitoring activities based on the new agreement can so they encompass not only announced, but also unannounced observations, unannounced visits, not only to the police board, to the border crossing points and police stations, but also to the green border. So unannounced visits can be done. And access to files, no matter whether these files are in printed form or also access to the information system of the Croatian Ministry of Interior. And these cases involve cases under observation, finally disposed cases, and reports of the General Police Directorate. And this is the advisory board. Currently, it's presided by the Fundamental Rights Agency. The Commission is involved. Frontex Fundamental Rights Officer is involved. The European Union Agency for Asylum, the Croatian Ombudsperson, also the Ombudsperson for Children of the Republic of Croatia, UNHCR, and IOM Croatia. And what we have done in the first year of the existence of the mechanism, there was a semi-annual and annual report that were published. As a response to that, the advisory board issued its recommendations, which were really helpful. And what I see as the major contribution of the mechanism was that it provoked a reaction by the Croatian. Someone, yeah.
Ano, lako mi stave.
If somebody has a device on, could you turn that off? Some chatting in the interpretation booths? Yeah. Okay, I think you can continue.
Thank you.
Excuse me, my apologies to interrupt. Iris seems to be muted to the online participants.
We heard the interruption and then we don't hear anything anymore.
Perfect. Now it's fine again. Your microphone is open again. Thank you.
Sorry,
Sorry, now it's again.
Could I ask you online to please not interrupt, because we do need to continue here. There's technical assistants who are trying to resolve the problem for the online participants. So thank you. Iris, please.
Okay. Third try.
Yes, just
Lucky try. Yeah. Okay. So what the FRA guidance is signaling is that the role of independent monitoring mechanisms should be much broader, that it should not only focus on screening, but general border checks, border surveillance, and all border operations at any time. And I think and now it's blocked. The last slide. Padla, can you help?
I just have to describe your content.
Okay, I'll describe it. Yeah. So
Yeah,
thanks.
Thank you. Yes, there you are.
So, and some other open issues is the monitoring location. So, why should the monitoring be limited to the external borders? Why should monitoring also take place at the internal borders and anywhere in the territory? To give you an example, railway stations and other places, they should be entitled to do monitoring also within the territory. Also, what I think is important to get very clear guidance, which are not provided by the screening proposal, on the rules of evidence gathering, processing, and obligations in case of allegations. So how are the monitorings to actually be done? What is the methodology of gathering data, of processing them, and then what happens if there are allegations? Are the monitoring mechanisms obliged to react? And finally, if case there are irregularities, what follows? Yes, the issuing of the recommendations, but what then? So this is all kind of left open, and I think it needs to be clear and harmonized at the EU level for all EU member states to prevent any potential abuse or loss of valuable information. And the last point that I want to make is, the big question: are the independent monitoring mechanisms really enough? Can they really respond to the challenges of what is happening at EU external borders in terms of the protection of human rights? Or are they just a little stone that can contribute to better control and prevention of any violent behavior? Thank you.
And thank you very much, Iris. And thank you for this extremely thorough and detailed presentation. I think there's many elements there that we can return to in the discussion. The question that you started with of the rapid development of tech, which is, I think, racing ahead of our ability to monitor the impact on fundamental rights, goes beyond our ability to establish and use justice mechanisms. So that's one element. And then when you're talking about the counterbalance there, the response to this, the monitoring mechanisms and how to ensure they're robust. And I think we benefit really from your practical experience in one of those mechanisms that's already been established. I would also note that some of these issues are on the table right now because we're into the final phase of negotiations on the asylum reform. The European Parliament has proposed certain amendments to improve the mechanism in the screening regulation, although rather limited still in terms of scope, even if their amendments are accepted. And we also see the proposal from their side for fundamental rights monitoring in the border procedure as part of the APR proposal. On the other hand, on the council side, we see the proposal for this new merged instrument bringing together crisis, force majeure, and instrumentalization, allowing for the situation you describe of greater restrictions and more risks being created at the border. So in this context, I'd now like to bring in Jonas. And the question Iris ended with, I think, takes us into the role that Jonas plays. Is it not enough to have independent monitoring mechanisms? No, we need a whole variety of accountability mechanisms inside and outside of institutions. And in the role as Frontex Fundamental Rights Officer, this is part of that structure of accountability. So, Jonas, could we have your reflections on what you've heard from Iris, but also the general context of how to prevent and ensure justice for fundamental rights violations at the borders? Thank you.
Thanks a lot, Catherine, and that's a nice little question there. I would like to do three things in response to that. I'd like to talk about the problems, some of the opportunities, and some ways forward. So on the problem side, of course, we have a regulation that guides this work, the European Border and Coast Guard regulation, which in its Article 80 talks about respecting fundamental rights for the community. So not for Frontex only, but for the member states and Schengen associated countries. And you may know, at least I think it's the case, that this is the regulation or the legal instrument in the European Union that is mentioning fundamental rights the most times. I haven't compared, but I would assume, since it mentions fundamental rights more than 200 times, and obviously for a good reason. So that's a problem, of course, that it's referring to fundamental rights. That's not the problem, but the implementation of this is a problem. It doesn't necessarily come with strong implementation mechanisms, but simply saying that this should be done. A second problem out of three that I limit myself to, the list could certainly be much longer. Frontex involvement differs between different operations. So we have in some contexts analysis, we have in other standing corps officers, we have some contexts with executive powers, we have aerial surveillance, etc. We have third countries where we don't have executive powers. We have third countries that are outside the European Union and unclear what powers we may have there in the future. So all that comes with greater uncertainty. The third problem is the leverage that we have as fundamental rights, as I have as fundamental rights officer, and the team that I have. We may have, and I think we have quite a strong leverage when it comes to the agency and its operations. But what is the leverage we have on the member states' practices? So we have some buttons to press, we have some possibilities, but of course, it's not, as I like to say, we're not the FBI. Moving then to the possibilities, and more positive, and also here I have three things, and also here actually I could have made a longer list, but in the interest of time. I've been in the office for 2 years, just about 2 years and a few days. We've spent, since I started, 2,000 days in the field in 20 countries, and also provided 200 training days to the standing corps officers, in addition to their regular training. So quite a lot of effort has been made. We have, through this experience, a really extensive comparative insight. We know what works, what doesn't work. We know what happens and what not happens to a very large extent. So a good outreach. The Fundamental Rights Office and Frontex as a whole also has a second advantage: much better standing and understanding and leverage. Again, this is an important word than we had a few years ago. We're able to insist on things. We're able to push for packages rather than a la carte, so set meals rather than a la carte. And I think that's really important to avoid that the member states look at Frontex as a cherry-picking opportunity, piggy bank or so, where we just get resources or assets or gear or kit. And an opportunity is also that Iris just talked about, the interaction with national mechanisms in various ways. So moving then to ways forward, also here, three things. And the overall concept that I would propose is not very unique or difficult, but it's EU as one. And that's what you alluded to, Catherine, that we need to solve this in a comprehensive way. So first element there, how could we ensure that the national capacity is a prerequisite? And we just heard about the screening regulation, that opens up for some possibilities. We have, since a few months, fundamental rights officer, if I can speak of the importance of this post also for the European Union Asylum Agency and for Europol. How could we three work better together? We started for sure, but how could that institutionally be made stronger and better? How can the complaints mechanism of these three agencies be weaved together? How can these complaints mechanisms be weaved together with national complaints mechanism? All those things would help alongside national monitoring mechanisms, again, that we just heard about from Croatia, but also the fundamental rights officer that Greece have appointed since half a year or so. And how can these national border monitoring mechanisms be ensured a required funding and effectiveness in terms of access? How can we combine this with EU funds, and how can we ensure that there is a certain sequencing, that you have something in place before you take the next step? Second point, how could we push more, or how can we have a stronger leverage to ensure compliance? Could there be clearer links between the findings, for instance, of what I propose, what we recommend, not only to Frontex but national and from me and from national mechanisms, and even from international, Council of Europe or international UN mechanisms? How could the recommendations there possibly be linked to availability of EU funds and or priorities for allocation of EU funds? And thirdly, could there be some kind of an independent overarching EU advisory / monitoring capacity? So not only for Frontex, and I'm not asking for more things to do myself, but certainly it would, when you think about, again, coming back to what I started with, Article 80, that fundamental rights should be respected by the whole community, not only by Frontex, but by the member states, Schengen associated countries. And if we think of also EU funds and how that could benefit from having stronger connections, so that the overall border management, wherever the sources come, even bilateral support, would fall within one sort of advisory monitoring framework. We could, of course, we have, of course, already the European Ombudsman, who has competence in this area, but maybe it would make sense to have some kind of dedicated capacity in this regard also for the European Ombudsman, not only for national monitoring mechanisms. And we already heard a little bit about the European Union's Fundamental Rights Agency, how they are involved in this process. That brings me to the promised 7 minutes, Catherine, and I stop.
Thank you so much, Jonas. And I would like to ask the participants here to reflect on those practical suggestions. It would be interesting to hear your views in the discussion. We will do as Philippe instructed and continue into the coffee break to allow this panel to have the full hour. One of the dilemmas that Jonas raises there is the question of the member states. For the Frontex fundamental rights structures, ensuring accountability of Frontex itself may be a more straightforward task. Whereas, as we know, many of the violations that we know to be taking place, because the evidence is plentiful, are carried out by actors deployed by the member states. So that brings us to the question also of Frontex's role. I would be remiss if I didn't mention the story that many of you have seen this week, where there's a question about whether Frontex should continue to work in Greece in that kind of context, which is also something we can look at in the discussion. So with that, we'll come to our second discussant, Eva, who will give the perspective of one of the member states most directly affected by this question of how to ensure respect for fundamental rights at the border. Please, the floor is yours.
Thank you, Catherine. Indeed, it's a great challenge for the member states to balance their commitments related to the fundamental rights and protection of EU's external borders. It is a complex task, taking into account the demanding duties of the border police officers. Border control officers are placed in a unique position. From one point of view, they have to facilitate the movement of people engaged in business, traveling for tourism, or individuals aiming to cross the border to seek international protection. From the other point of view, at the same time, the officers have to guard the national security from the entry of individuals involved in criminal activities and to prevent unauthorized entries. Yesterday, we heard that strong external borders is a technical requirement to enter Schengen. So for Bulgaria, as being a Schengen candidate, you can understand us that we have to fulfill our responsibilities in the border guards Bible. This is the Schengen Borders Code, and to implement all measures regarding border control activities. The task becomes even more difficult when it concerns loss of human life. But here I just want to attract your attention not only to the human rights of the persons that are trying to cross the border. I would like to draw your attention also to the human respect of human rights of the border guards officers. Unfortunately, Bulgaria has recently witnessed several cases of brutal violence by smugglers against police officers. People trying to reach Europe are also disposed at risk during their journey. So this is another issue that is very important when we discuss what kind of measures should member states take in order to protect the external borders. It is not issue only of protecting the external borders, it is also issue of protecting the human lives. All this requires a robust border and migration management system accompanied by a human rights monitoring mechanism. This is for sure. The protection of fundamental rights is an unconditional and essential component of effective integrated border management and part of the Bulgarian integrated border management strategy. Fundamental rights monitoring at the Bulgarian borders is systematically and regularly carried out for border management activities. I just briefly present how our national system for monitoring of the human rights is organized. At first place is to guarantee that the human rights are respected. This requires a stable and solid legal framework. So this framework is in place, and all provisions and all legal instruments that are used at EU level and in international level, I mean conventions, they are reflected also in our national legislation. And the second place is how we actually guarantee that the human rights are protected. So this is implemented mainly by the independent mechanism for monitoring of the protection of human rights, where the ombudsman and the courts play the main role in this regard. Bulgaria cooperates in this area with Frontex, Fundamental Rights Officer, and with FRA as well. Close cooperation is also undergoing with UNHCR and Bulgarian Helsinki Committee for matters concerning the international protection. The mechanism has a broad thematic mandate, proper implementation of non-refoulement principle, prohibition of collective expulsion, safeguarding family unity and the best interest of a child, special attention to vulnerable persons, access to asylum procedure, access to effective judicial remedies, dignified living conditions. Actually, this is the whole spectrum of fundamental rights that could be somehow infringed at the borders, and as previous speaker said, inland. Internal, regional, and national bodies regularly monitor compliance with human rights. For example, UNHCR and Bulgarian Red Cross both have specific mandates in this area. They can check, they have also access to documents, registers, and records, including files, videos, and electronic records, as well as they have access to the detention and the reception facilities. Bulgarian authorities take into account all the findings and recommendations made by various actors, part of the monitoring mechanism, because our aim is to permanently upgrade this mechanism. how we are promoting the respect of human rights. So this is from one point of view, this is by informing the persons about their rights. Here again, we rely on the assistance of UNHCR. They provide us brochures that are accessible to the persons immediately when they cross the border and at the places of accommodation. Also, we relied here on Frontex, on FRA trainings. Regarding the trainings, Frontex Code of Conduct is the framework for our border officials. Border police officer is certified by Frontex as a trainer, and he will continue these specific training sessions on human rights as a trained trainer system. A part of this, all border police officers receive solid fundamental rights briefing before all everyday operations, and so this is an ongoing process. And because of the time, I want to jump quickly to the next steps and the screening regulations. So yes, we have our national mechanism in place, but we would like to make it a specific monitoring mechanism and to give it more to somehow to structure it better. That's why we are now working at national level for upgrading this mechanism. We are analyzing the FRA guidance. And also we are analyzing the experience of Croatia in this regard. In September, we are planning to have a dedicated discussion on what could be the framework of this future mechanism. For sure, in this mechanism, again, international and national organizations dealing with human rights will continue to play a major role. The important elements concerning this mechanism are undoubtedly the independence, accountability, and what are the consequences of breaching the fundamental rights. They will be even better defined because now they are in place, but as I said, we want to upgrade this mechanism and to harmonize it with existing ones. What else I can say? Maybe I will stop here because the time is not enough. Yes, of course. And if you have questions towards me, I'm here to answer that. Thank you.
Thank you so much. And again, very interesting practical examples from a country dealing with these questions. I would like to open the floor to questions and comments from the audience. So I think we'll take 3 and then we've only got 5 minutes. So I'm going to take 3 and then we'll come back to our panelists. Lilian.
Yes, thank you, Catherine, and thank you to all speakers. I have 2 questions. The first is for Jonas Grimheden. So I was wondering, because since 2022, the Schengen evaluation mechanism has also an explicit focus on upholding fundamental rights, and I was wondering whether the vulnerability assessment of Frontex, which in the regulation is let's say, formulated in drier terms, whether in reality it also focuses on the respect of fundamental rights, or is it more of a technical level, let's say, assessment of readiness of equipment, or do you go into the nitty-gritty also of other elements, directly or indirectly? And then for Iris, thank you also for sharing your experience with the Croatian mechanism. I was wondering, because I saw in your advisory boards that there were these linkages with EU agencies and the EU level, but I was wondering whether beyond the presence of these actors in the advisory board, were there any links, structural or others, with ongoing processes such as monitoring processes, let's say like the one that I just mentioned with Frontex, etc.? Do they exist, or are we going towards I don't know, duplication, multiplication of mechanisms that actually are pointing to the same things, or is there any way that these processes can feed into each other? Thank you.
Thank you. And a point raised also by Jonas of trying to bring these together to make one effective approach rather than lots of fragmented approaches. Could we take the question in the back and then we'll come to the table?
Thank you. Romain for State Watch. I have some question for Iris. So what I actually, to go a bit further from what Catherine was talking about on border tech, what has been your experience of the monitoring of the mechanism in Croatia surrounding border tech? And so is there, for example, also dialogue between the DPA, so the data protection officer at the national level, and the independent mechanism? And the last one is about the European information system, because one of the objectives of the system is to expand the control at the external border towards everywhere inside the territory. Does it mean that the role of the independent monitoring mechanism will cover all the territory? And how can an independent mechanism with, I believe you mentioned 6 monitors plus yourself, cover that much cases? Thank you.
Thank you. We'll take the last question and then I'll come back to the panelists, please.
My question also refers to the monitoring. I think this is always a question of coordination of the monitors, and we had a lot of experience in Austria with fundamental rights monitoring, and I see a certain problem in the coordination, and perhaps also in a certain form of if even the independent monitoring becomes a structural process, the actors are not really controlling each other. It might be the consequence. But a concrete question, also referring to the monitoring, you said, Catherine, I think the personnel seconded by Frontex from other member states is acting in the member state, and you have a variety of actors. I think the attribution of acts to the member state is central. So you have this attribution to the responsible member state. This has consequences for the monitoring as well. And perhaps also I had PhD students who did intense research on Frontex, the new agency, and they always had problems with access to documents and access to materials. So this is a situation which could be improved, I think, because academic monitoring, PhD students, that should be really essential in providing data and academic opinions on the issue.
Thank you very much for those questions. We're going to come back to the panelists and then end for the coffee break, as I'm told the time is limited. So I want to take the panelists in the same order. So Iris, please, if you're ready.
Yeah, thank you. Thank you so much for the questions. So as regards Lillian's question on, the challenge of duplication of mechanisms and whether they feed into each other. So the current pilot project, basically, you have monitoring that is done by the national monitoring mechanism. You have monitoring that is done by the Croatian Ombudsperson's office, and the Croatian Ombudsperson's office sits in the advisory board. And that was one of the issues that was raised by the ombudswoman, that, we basically have, monitoring that is done by two bodies. One has the constitutional competence to do it in Croatia. The other one is just based on a just regular agreement. So its role and its competence to do it is much weaker, definitely. And then, of course, you have EU monitoring, which exists on top of that. And I agree with you that it's absolutely necessary to ensure that there is some coordination and that each monitoring kind of contributes to the other one. And I think this is something that has been actually kind of suggested by the European Parliament in its position with regard to the screening proposal, that there should be a clearer link between the independent monitoring mechanisms established at the national level and the Schengen evaluation mechanism. So, on the one hand, this is something that can contribute to the monitoring and the results. On the other hand, I don't see this as a problem by itself, that as a consequence of that, you shouldn't have more mechanisms. I think the more mechanisms you have, the more monitoring you have, the better. So in that respect, I don't see the problem with accumulation, but I think they need to coordinate and feed into each other. And then as regards the question on tech, yeah, so we basically, the only technology that we saw in real life, and I haven't seen it because I'm not doing the monitoring. So the monitors are these 8 people that are doing it in the field, and I'm just in the coordination board. They've seen, the use of tech at the border crossing points, at the police stations. And we have just, with the new agreement, gained access to the information system. So the first agreement that existed for a year, it was explicitly stated that we do not have access to the information system. And then when we insisted on this, because this is crucial, and I agree with you, what is the likelihood of these 8 people to actually spot something? Very low. So it's really important to have the information, to have access to the information system. And then we asked for a training to be done by the Ministry of Interior, which we did get. So we had a training organized for the mechanism in Croatia, where we basically learned how the information system works, the national information system, and it's very complex, but okay, we got it. But the problem that you have also mentioned, and I think it was also mentioned by Ulrike, is access to the information system might not solve the problem. Now we have access to the information system, but is everything there? Are pushbacks there? So, things that might be most problematic are nowhere written, nowhere registered. So that's the hugest problem, I think.
Thank you very much.
So Schengen and monitoring, if I got that right. So on monitoring, if I start with that. So in terms of coordination, I think it's key, of course. At the same time, we also benefit from just reading each other's reports, etc. But a few concrete examples. We have scheduled together with the Croatian monitoring mechanisms to do a joint monitoring day or week in September. We already had in March a joint monitoring with Europol's Fundamental Rights Officer. We will have next month with EDPS, the European Data Protection Supervisor, in a country. So we try to work informally by just being in the same place at the same time and try to draw on each other's monitoring work. And I think that's a good start. That could be certainly more formalized and encouraged. Personally, for the monitors that I have at my disposal, I make sure that they rotate, to make sure that they are independent and objective. Attribution to member states, yes, very important for us. If we get a complaint, for instance, if it relates to a Frontex standing corps officer, we deal with it. If it relates to an officer from the member state, I hand it over to the independent monitoring or independent investigative authority in that country. be it an EU country or a third country. And access to documents, at least since I started, I've responded to anyone. Having been in academia myself, I respond to all PhD, master students, undergraduates, whatever you want. And I spent time taking interviews or doing interviews with them, trying to answer questionnaires. Access to documents more generally is, of course, something that the agency and also me personally spend a lot of time on. I guess we get I spend probably 1 or 2 hours every week myself on access to public documents that we provide. And for the agency, there are probably 10 full-time equivalents that spend on access to documents only for Frontex. So I think we're doing a lot on that. At the same time, we could improve certainly on the overall transparency, and we're working on that. Coming to vulnerability, I think that's an area just like risk analysis, where I have slowly tried to push since I started, that it should be more fundamental rights oriented, that should be part of the risk analysis and part of the vulnerability assessment. You mentioned also the Schengen evaluation, and I think there we have a good progress through the Fundamental Rights Agency that takes part in the Cheval, and they provide that interface and also an interface with me, because I interact with them extensively. So I think that helps a lot to ensure that there is a greater fundamental rights dimension to Cheval and vulnerability assessment, etc. Thank you.
Great, thank you very much. Eva, some final responses on your side.
Yes, what can I add? It's for the last topic, Schengen and monitoring. Our intentions for the future mechanism is that the tasks and activities of new mechanism will guarantee the synergies with the existing mechanism by completing the activities of the Ombudsman, the Fundamental Rights Officer of Frontex, vulnerability assessment made by Frontex, and once Bulgaria becomes a fully fledged Schengen member state, of course, that this mechanism will take into account the findings of the Cheval evaluations. This is for me.
Thank you. With that, I'd like to close this panel and thanking all the panelists for extremely interesting presentations based on practical experience. I think we heard a lot about how things are implemented, the laws and the tools that are available, both the opportunities but also the limitations that persist in this extremly important area. I'll hand the floor back to Philippe for instructions to participants.
Well, unfortunately, the bad guy telling you that we have only a 10 minutes coffee break.